what happened was that he called and asked me to meet with him, and sat me down and told me that he wanted me to be Chief Justice. That Chief Justice should say to them, well, what we're going to do with this courthouse while we're not sending you to prison is we're going to have a bunch of blacks in there rioting, screaming in a courthouse, threatening to kill a judge, threatening to kill a defendant. I felt that it was just wrong. So the idea that we're an activist court and we defer enormously to the legislative will, always have. We should. They make the law. When they make the law, if we don't follow it, we're lousy judges.
In 1948, New Jersey got a new constitution and a new court system. Since then, 5 men have served as Chief Justice of the state Supreme Court: Arthur Vanderbilt, Joseph Weintraub, Pierre Garvin, who died after 6 weeks in the job, Richard Hughes, the former governor, and since 1979, Robert Wilentz, who's commonly seen on the news, photographed from this side, sitting in this chair.
Wilentz is the leader of a court that itself is seen as a leader. It's the court that ordered suburbs to create lower-income housing in the Mount Laurel II decision, that held hosts liable for the drinking of their guests, that expanded the right to die, and outlawed the right to carry someone else's baby for money. Wilentz was 52 when Governor Brendan Byrne tapped him to succeed Chief Justice Hughes. Although his father was a legendary Democratic boss and kingmaker who helped presidents and governors get elected, the son, it was said, was chosen only after Byrne asked 10 people to name the best lawyer in the state, and Wilentz was on every list.
I believe that Robert Wilentz represents the right man for a tough job at the right time.
7 years later, a Republican governor would renominate the liberal jurist with Democratic roots, only to run into a buzzsaw of opposition from Republican state senators, especially when it became known that New Jersey's Chief Justice was actually living in his New York City apartment. In a dramatic hearing before the Senate Judiciary Committee, Wilentz revealed that his wife had cancer and needed to be near her New York doctors. He was not about to move her or leave her.
I am not going to leave my wife in a position that will devastate her life, her personality, everything about her.
Wilentz survived the ordeal, but just barely. The Senate reconfirmed him by the slimmest margin possible. As Chief Justice, Wilentz is both Chief Judge and Chief Administrator of the entire court system, a system whose stresses and strains he has personally tried to inspect in recent years. He got embroiled in more controversy in 1990 when he banned a film company from the Essex County Courthouse because Warner Brothers wanted to use it to film a riot scene. The year before, when a smoldering illegal dump in Newark melted the interstate highway above it, and Wilentz publicly chastised a judge for not shutting the dump, the Chief Justice was roundly criticized for his disloyalty to the system. More controversy has surrounded the Supreme Court's reluctance to uphold death penalty convictions and its 1990 Abbott versus Burke ruling that ordered more state aid for urban schools so that poor kids could get the same amount spent on their education as kids get in the state's wealthiest suburban public schools.
We sat down recently with the Chief Justice for his first major television interview. We met in the study of his home in Deal on the Monmouth County shore. Chief Justice, I want to thank you for inviting us into your house. We've been trying to do an interview with you for years now, and this year you've said yes. I wonder if there's any particular reason why.
I wish I could identify the reason why. I think it's that one morning I awakened and I felt real good. And I said, I'm tired of saying no. So I'd say yes. As I think about it, while I'm not sure that this is exactly how the motivation worked, I've been Chief Justice for about 14 years now, and I guess I felt those people who might want to see what I look like in something other than the robes and something other than sitting at the bench were entitled to take a look if they wanted to.
We're here in the home in Deal that you have been living in since the legislature forced you to come from New York to New Jersey. How is it living here in Deal?
Well, I won't go into the premise of the question.
We'll get to that
for a moment.
We'll get to that.
It's very, very quiet. In the summertime, it livens up a bit. Most of the people who have homes here don't stay here all year round. They just stay here for the summer. So comes the middle of September or even early September, it becomes extremely quiet. It's very pretty. I'm used to it. I've spent all of my summers here for most of my life. So I like it, and I love this house.
What do you do in your spare time, if the Chief Justice has any spare time?
I really spend practically all of my time with the work that is part of being Chief Justice. I was sick a couple of years ago, and the doctor told me that I couldn't work for a couple of months. So at that time, I found out that I enjoyed watching baseball. So when the baseball season comes, I spend a little time watching the Mets. Football season, once in a while, I've been known to watch the Jets. This is all on television. And I don't mean this program, I mean when I watch. But my life has been mostly, almost completely, just work.
Let me ask you a little about your life and how it started. Your father is a legendary figure in New Jersey political circles. He was the Democratic leader of Middlesex County for nearly half a century, I believe.
Yeah.
The word that's used is boss. He was the boss of Middlesex County. Does that word capture what he was about, or does it do him an injustice in some way?
Well, it depends who's saying it and how they mean it. He certainly was the leader, and a powerful leader, and very often whatever the policy or patronage issue was, what he said went. So I guess in that respect he was what you consider a boss. He was very important in state government as well because of his position as a Middlesex County leader. I think he was a very good leader, very effective leader, and a very honest leader. So if a lot of people who call him the boss in Middlesex loved him very, very much. I suppose some people find it difficult to be fond of anyone who's called the boss.
You were fond of him?
Very much so. He was a great lawyer, too. Absolutely superb lawyer.
He made his fame prosecuting the Lindbergh kidnapping case as Attorney General in 1935. He was the prosecutor who sent Bruno Hauptmann to his death. And
correct.
That verdict has, in recent years, come under some question. Some people think maybe the wrong man got sent to the electric chair for that crime. I wonder if you have any feeling, one way or another, about whether Bruno Hauptmann was innocent or guilty.
I have no feeling about it because although I'm hardly a student of the subject, my belief is that he was guilty, and I have no doubt about it. Whether I should have doubt about it may be a different question, but I don't have any.
It's said by some that if that prosecution were presented to your court today, that your court would reverse that conviction because of improper argument, the inflammatory nature of your father, the prosecutor. By today's standards, that conviction wouldn't hold up.
I suspect the comment is made less on the basis of a study of the case than it is on the basis of the number of convictions that we've reversed. But there's no question that the rules concerning evidence, prosecution, prosecutorial comment of today are significantly different. My understanding is that of the new evidence that's been unearthed or that's been made available to the public, if anything, tends to further fortify the case against Hauptmann. But I have no idea how our court would rule.
Who else besides your father have been major influences in your life?
My wife.
Tell us a little about her.
Well, I went to law school and became a lawyer and plunged into the law and found it very difficult and worked terribly, terribly hard. We lived in Perth Amboy, and she became interested in the schooling of our kids, and she became interested in the schools and in education, and became extremely active in Perth Amboy in trying to improve education, trying to get parents interested, and without any question became the leading advocate for better education in the Perth Amboy school system. And I think that her activities drew me even more into the community and into community involvement than I had been before. And her drive and her courage and the things she undertook, and I worked with her, but she was out front. She was the one who was really the campaigner in that. And we were very, very close, and she was a very, very substantial influence in everything I did.
Well, you did go public in the 60s. You ran for the Assembly, and you served in the Assembly
Right.
for 2 terms. You quit the Assembly, and I'm told it's because there was a conflict of interest law passed that said the partners of lawyer legislators could no longer represent clients before state agencies, and that you had supported that bill but then resigned after.
Yes, I voted for the bill and resigned the same day. I thought it was a very, very sensible bill. I think it got vetoed or something of that kind, or conditionally vetoed, but I felt it was improper for certainly for the legislators themselves to appear before state agencies, and I thought it was quite appropriate to extend that ban to the law firms that they were connected with.
Well, did you leave? I'm sorry, go ahead.
And I had inflicted enough damage on the firm simply by being an assemblyman, because I really spent most of my time being an assemblyman. And the thought that in addition to not being able to serve the firm as a lawyer, but also to impose that restriction on them was just more than I would even dream of asking them to bear, and it would have been totally unfair. I didn't even ask.
The firm is Wilentz, Goldman & Spitzer,
Right.
Your family's firm.
That's
your
right.
Father,
My
your brother.
father's was the founder of the firm, and he was the boss of the firm.
Was it tough to leave the Assembly, or were you ready to leave anyway?
I enjoyed being an assemblyman very, very much. I wouldn't describe it as tough, but no, I wouldn't say that I was ready to leave. No.
In 1979, Governor Brendan Byrne selected you to be Chief Justice. How did that come about? How did he let you know that you were his choice?
You would have to ask him, I guess, how it came about. I know what happened was that he called and asked me to meet with him, and sat me down and told me that he wanted me to be Chief Justice.
And what did you say?
I told him I would have to think about it, because there were a lot of different things I had to think about. I had never, ever thought of being a judge of any kind, never had any desire to be a judge. As a matter of fact, on occasion had tried, and I don't know if succeeded, but to persuade people in the firm and not to become judges, because I was committed to the firm and to being a lawyer. So I had to think about money and quite a few other things. So I guess it was several weeks later that the idea began to possess me. The thing that I never thought about before. I decided that I would want to be Chief Justice, and I told the governor that if he decided that's really what he wanted to do, that I would be willing to be Chief Justice.
Well, I guess the idea has possessed you ever since.
The office has, certainly.
How has it changed your life? What would your life have been like had you said no?
No idea, really. I mean, it's hard to figure those things out. I worked very, very hard as a lawyer. And one thing I was fairly confident of was that I couldn't possibly work any harder. I have worked harder in the sense of longer. In other words, the hours that I spend at the work are more hours than I spend as a lawyer. But I love this job, and I love what it means to be a judge. I have enjoyed almost all of the administrative work. And the kind of pressure that I felt as a lawyer, to me, exceeds the kind of pressure that I feel as a judge. I have been more relaxed as a judge than I ever was as a lawyer.
You say you love the job. What's the hardest part of the job?
Well, for me, the hardest part of the job is trying to do two things, either one of which should take full time. One is being a judge, and the other is being the administrative head of the court system. That's what's the hardest part of the job. And I have not resolved that. I have tried very, very hard to spend more time being a judge than I had spent in the past. But it's now 14 years and I haven't succeeded.
You spend 2/3 of your time, I read, as the administrator.
That's still, I think maybe I'm down to 60%, but I still spend more of my time on administrative matters than judicial matters.
Well, I want to ask you about the court system, but first I want to ask you about some of the controversies that you have managed to get yourself in the center of over the years, beginning with the fight over your reappointment in 1986. Republican legislators, senators, wanted to deny you your reappointment when you came up for tenure review after 7 years, and they cited the fact that you were living most of the time in New York City, and you said that that was because your wife was in ill health and needed to be near her doctors, and you became a political football, really, for about 2 months, and the intimate details of your domestic life were splayed across the front pages of newspapers for weeks. What was that all like?
Well, it was extremely unpleasant. I felt that if I wanted to continue to serve, I had to tell them what the reason was for something that is clearly not expected of Chief Justice. It isn't that I spent all of my time in New York, but I spent from 1983 on every night in New York and had dinner every night in New York with my wife. And I felt they were entitled to know why. And it was very, very unpleasant. That's what it was like.
The defining moment of that whole process, I think, was when you defiantly said to the Senate Judiciary Committee, "Senators, I am not going to leave my wife in a position that will devastate her and her personality." I remember it well. I was there. It was one of the most dramatic political confrontations I've ever covered. Looking back on it now, did you handle it correctly, do you feel? You certainly showed where your priorities were, and a lot of people applauded at the time.
I don't know if I handled it correctly. I couldn't handle it any other way. That was the truth, and it remained the truth.
Was it really the residency that your political opponents were concerned about, or were they using that, do you think, to get at you for some of the so-called activist decisions of the court, particularly the Mount Laurel decision of '83 that forced the suburbs to zone for low-cost housing? Were they attacking you for ideological reasons, or was it the residency that precipitated that confrontation?
I just don't know. I do not know. I have never tried to resolve in my mind whether I would deem it appropriate, proper, justified for someone to vote against reappointment of a Chief Justice solely on the residency basis. But certainly, reasonable people could argue about that. In other words, if someone said, I have no objection, as a matter of fact, I favored the Mount Laurel decisions, but I just think it's, even though the Chief Justice may have very good personal reasons to be in New York, as often as he is, I just don't think it's right. I would find it difficult to say to that person that that's an outrageous point of view. I'm not sure I'd agree with it. But I don't know what it was. I don't know what their motivations were. Apparently, my recollection is there. I hope you're not going to contradict me on this, but my recollection is that my qualifications as such were not in question.
They certainly were not.
Yeah, but it was the residency, and what else it was, I don't know.
There was that excruciating evening in the Senate when the vote board was stuck at 20-19 and you needed 21 votes to keep the job. And at that point, you made a concession in order to get that 21st vote, didn't you? You agreed that you would abide by a residency law if the legislature passed one and if it was constitutional.
Yes.
Or if your wife's health improved.
She got better, is the way they said it.
It was necessary to make that concession in order to get that 21st vote?
I will never know whether it was necessary or not, but I made that concession.
Did you ever think about quitting during that period?
Not at that moment. No, I did not. No, I was in a fight, I guess, and I wanted to win the fight.
You feel as if you won the fight?
I got reappointed and confirmed. So I guess to that extent I do.
Do you still own the New York apartment that was at the center of this dispute? Spend time there?
Hardly ever. Hardly ever there. My daughter has stayed there from time to time when she comes from Albany with her kids and her husband. She is basically a Manhattan person at this point, and she no longer has her own apartment available. So she stays there from time to time. I go there, all of my kids used to be in Manhattan, and I would go in there for Christmas. We'd get together and I'd stay in New York for several days. Most of my physicians happen to be in New York, so when I have to see a New York physician, I go there, but I'm there very, very rarely. For all intents and purposes, the apartment is vacant, and I haven't quite made up my mind what to do with it when my daughter's need for it ceases, which will be, I don't know how soon that'll be.
So the reappointment fight is over. You don't carry bitterness around with you over?
No, I don't at all. And if there were a residue, I would fight very hard to get rid of it, because I can't afford to.
Another controversy that you got yourself embroiled in was the Bonfire of the Vanities case, where Warner Brothers was going to use the Essex County Courthouse to film a raucous scene for the movie Bonfire of the Vanities, and Essex County was going to get $250,000. And you said, they can't use that scene. It will undermine the confidence of the African-American population in the judiciary of this state. A lot of judges and legal scholars felt that you were wrong to engage in what they called censorship. And in fact, the federal judge said that you were engaging in censorship and what you were doing was unconstitutional. Were they all wrong and you were right as you reflect back on that?
Well, if you're talking about were they all wrong on their view of the Constitution, my view is that what I did was not constitutionally prohibited. My view is that what I did was constitutionally permissible, but standing there all by myself with practically everyone disagreeing, I must say, I don't want to suggest that I have total confidence that I am or was right in terms of the Constitution. But I still believe that. I still believe that it was constitutional and is constitutional. The judge was reversed, but of course it was on a different ground. The Court of Appeals, the United States Court of Appeals, never touched the constitutional issue, neither agreed with him nor disagreed with him. In terms of what I did, do I think I was right? I do. I very much think I was right. And
people found it odd that a champion of the Bill of Rights and of the First Amendment would be engaging in suppression of speech, to quote Judge Politan. You see the paradox there, yes?
No, I don't see the paradox. Yes, certainly. If one views this as suppression of speech, then I see the paradox. If one is good enough to regard me as a champion of freedom of speech, and I think I am. There are several things about what I did. First of all, I had no desire to suppress anyone's viewpoint. I didn't want to stop anyone from hearing whatever it was that the movie producers thought they could show through Bonfire or the Vanities. Happens to be one of the very, very few books that I've read since I've been Chief Justice, other than law books. And I think it was an absolutely superb book. And I have no desire to touch one iota of what that author wanted to show or what the movie producer wanted to show. Just a question of whether it's got to be filmed in a courthouse. Question of whether that scene has to be filmed in a courthouse. Most states that are trying to accommodate the movie industry, as we are, as New Jersey is, have no trouble in their courts with movies. They let most of the scenes be shown in the courthouse where someone wants to use the courthouse, and when they don't want to, they say, we don't think that's right for a courthouse. And it's over. No one sues anyone. I'm not saying they should or shouldn't, but that's the fact. Just so happened that the way my life works, I said, I think this is not right for a courthouse in New Jersey, or a courthouse in Essex County, to have this scene filmed. And my view is that the Constitution doesn't prevent an accommodation between the wish of the court system as part of the state of New Jersey to try to accommodate the state's desire to encourage the movie industry, and the court's ability to protect its own legitimate interests, not because it wants to knock someone's viewpoint off or censor, but because there is a group that's been identified whose confidence in the justice system is fragile, very fragile. And if what happened in Los Angeles doesn't instruct people on just how fragile their confidence is in the justice system, I don't know what would. So the thought that blacks and minorities in general, but blacks especially, having that little confidence in the justice system, should be subjected to their Chief Justice taking their courthouse, where their sons, husbands, brothers are regularly shipped through and sent out to prison, their Chief Justice, who names the presiding judge of the criminal division, who approves of all of the judges who send their sons and brothers to prison, who names the assignment judge, that Chief Justice should say to them, well, what we're going to do with this courthouse while we're not sending you to prison is we're going to have a bunch of blacks in there rioting, screaming in a courthouse, threatening to kill a judge, threatening to kill a defendant. I felt that it was just wrong to say that to them, to give them all the more reason not to have confidence in the judiciary. If the Constitution prevents me from that kind of protection of what the judiciary requires, and I feel bad about it.
You know, it's said of you that you are so concerned about protecting the reputation of the judiciary that you become heavy-handed and create public relations problems for yourself, as in this Bonfire case that you just spoke of, as in another case, the Hub recycling case, where a recycling dump erupted in flames. melting a highway, disabling a major artery. The public was inflamed. A judge had allowed that dump to stay in business instead of shutting it down. And you, to appease the public, it seemed, put out a statement criticizing the judge. And you then got roundly criticized by the State Bar Association, and it was said that other judges felt this would have a chilling effect on them in the future. Is this a tendency of yours to be so concerned about the reputation of the judiciary that you will get yourself embroiled in controversy?
Apparently. That is one of the things that I did that I'm not sure I was right about. But I would like to explain briefly why I did it. I guess you could express it as saying I wanted to appease the public. I'd express it slightly differently. I didn't want a very large portion of the state of New Jersey cursing the judiciary every day as they went to work and came back from work for 6 months to a year. When that fire took place, the governor said it was the worst transportation disaster or emergency that he can remember in his lifetime. It was thought that the highway would be unusable for, I think it was 6 months to a year. I forget the exact amount, but it was a long, long time. It was thought that tens of thousands, I don't know how many, whether it's 100,000 or what, very, very substantial number of commuters were going to have to spend an hour more to get to work every day, an hour more to come back from work to their homes every day, perhaps because a judge had made a mistake. I felt that if indeed the judge had committed an error, the judiciary ought to tell the public right out front, we made a mistake and we regret it very, very much. The alternative was to say the matter is up on appeal and we will have no comment on a matter that's up on appeal, but the Attorney General could have taken an appeal because we let people take it. The Attorney General should have done this. To me, to do that would have not risked, but would have made certain that this very, very substantial group of workers of all kinds of lower management, middle management, ordinary factory workers, who are really terribly, terribly, not simply inconvenienced, but their life dreadfully affected, saying, you know, what's going on here? So I had someone look very closely at what had occurred in the case, not me, another judge, very carefully, and make a fairly certain determination that the judge had indeed made a mistake. And that was the reason I did what I did. As I look back, perhaps, well, there are two things you look back at. Number one, the highway got cleared up one hell of a lot faster than anyone thought it would. And the other thing is that maybe what I thought I was saving wasn't worth the cost of what I saved.
The cost being antagonizing?
The cost, it's not just antagonizing, there's a principle involved. The principle is that the only way you say that a judge was wrong is when you review his opinion as a judge, as an appellate judge, with the record before you, with counsel arguing on both sides. So it was unfair to that judge. But that's why I did it.
If you are that sensitive to...
Well, that's the point I'm trying to make, is on the phrase, that sensitive. That the potential impact was enormous, the potential impact on the judiciary. In other words, it wasn't, as I view it anyway, a case of incredible oversensitivity on my part. It was a question of responding to an absolutely unprecedented potential fury on the part of a huge body of people directed against the judiciary.
Well, when there's fury in the public on an issue like the death penalty, for example, after the court, your court, strikes down 27 straight death sentences, overturns them, and the public gets inflamed, and you finally uphold a death sentence, Robert Marshall's death sentence, to what extent is that also listening to the fury of the public and responding to it?
Not at all. Not in the least. Not one iota. It may be perceived that way. I read of some people who have said, oh, the court is finally listening to the public. The notion that a court, in my view, principled enough, courageous, in my view, enough to reverse 30, however many it was, despite the obvious difficulty, understandable difficulty of the public to comprehend what we were doing or why we were doing it. The idea that a court that has that kind of strength in the view, in the face of that kind of public opposition, suddenly, because it affirms one, suddenly is caving in. I would think the obvious conclusion would be, finally, a case came before the court that it felt met its standards. And that's what it was.
Prior to that, when you were overturning all these death sentences, people thought that perhaps the justices are against capital punishment and are making it as difficult as possible for this law to be carried out. And I've read, you once reportedly told a court employee that you're against capital punishment. I don't know if that's true. Are you against capital punishment?
I don't think it would be fair of me to give you other than a full response to that question, and I don't think it would be right of me to give you that full response. I will enforce a capital punishment law as the legislature writes it to the best of my ability as a judge. The main arguments about capital punishment that I find troubling are arguments concerning its effectiveness and its cost. But I have absolutely not the slightest, but not the slightest inclination to reverse a death penalty conviction because I have some kind of bias against capital punishment, but not the least.
You spoke a little earlier of your role as chief administrator of the court system in this state. Is the court system badly backed up? One judge said to me that the system is choking on itself. Are the backlogs in the civil part and the criminal part and the family courts, are they the most serious problem facing the courts?
They're very serious. I guess perhaps they could be called at this moment the most serious.
Are you addressing those problems?
Yeah, we are, and so is the governor, and so is the legislature in the form of giving us more judges. We had a period of time when the criminal calendar was so overloaded because of the enormous increase in arrests, indictments, indictable complaints resulting from the drug epidemic, where we had to take, where I took a whole batch of judges out of the civil division and put them in the criminal division, because that's where I felt the society's priorities were. And the result of that was that the criminal division did not get slaughtered. At least its harm was contained to some extent, but the civil division was terribly, terribly affected. For Since I became Chief Justice, the number of complaints filed has gone from 700,000 a year to over 1 million, so it's gone up by about 50%. Until July of 1991, the increase in the number of judges during that same period went up only about 27%. So it's just more and more and more and more filings and not enough judges added. We've now added quite a few more in the last year. But we've got a lot of catching up to do. In the civil division, the average time it takes if you really want to try your case before a jury is much, much, much too long. Criminal division, while we're not nearly in the kind of shape I'd like to be in, is not too bad, and I see it as getting better and maybe within a year or two actually reaching the kinds of goals that we think it ought to. Family division, the waits are intolerable, not as bad as the civil division, which is the worst. And we will undoubtedly need more help there.
Let me ask you about your court, the High Court. How collegial are the 7 of you? How much time do you spend together? You really only have a conference every couple of weeks, I believe.
Well, we are ordinarily together 3 times every 2 weeks. In other words, we're together on oral argument days, which are Monday and Tuesday of a week. And we're together all day on Monday and Tuesday. So while you may count it as 2 days, it's 2 somewhat long days. And then we're together the next week 1 day, which is the following Tuesday, which is generally decision day plus a lot of other kind of work. All day we're together on that day. So we're together a fair amount, but you're essentially accurate. That's when we're together. We are extremely collegial. We get along extremely well.
You also produce a lot of unanimous decisions. 3 out of every 4 decisions coming out of your court are unanimous. How do you, as Chief Justice, take these 7 strongly opinionated people and rope them in each time, 3 times out of 4?
Well, achieving unanimity is difficult for 7 people. And if I allow this program to convey to my colleagues the notion that I think that I rope them in and somehow corral them into unanimity, you'll never see another unanimous opinion. We talk a great deal about the cases. We try to resolve our differences. In other words, it's a very simple thing to meet and vote, and it's 5-2, and then you go on to the next case. That's a very easy way to handle your work, but we don't do that. When we differ, we argue, discuss, try to reach agreement. We all believe that it's good for the public and good for the judiciary if a court such as ours can reach agreement. If we can't, we can't.
Well, your court certainly looks good compared to the Supreme Court in Pennsylvania, where the justices are openly feuding and accusing each other of impropriety, and the highest court in New York, where the chief judge, your counterpart, has had legal problems that have cast a cloud over his court. Your court keeps getting rave reviews from law professors around the country. Lawrence Tribe of Harvard Law School called it the best Supreme Court, state or federal, in the nation. Of course, that was back in the mid-'80s. I don't know if that's still true. What makes New Jersey's system strong?
I think what has made us strong is the way the court system started, the modern court system. In other words, it started back in '48, and it was preceded by a tremendous drive for reform of the court system. I don't know enough about United States history to know if it was unparalleled or unprecedented, but there was a group of lawyers and legislators who were convinced our judiciary, our judicial system was terrible. It was thought to be one of the worst in the nation. And as some professor said, we changed it from one of the worst to the best. But it wasn't only that they changed and made it a unified court system with a strong Supreme Court and a strong Chief Justice, but they focused the attention, I think, of the people of this state on how important a judiciary was. And it wasn't just these very, very high-profile people, but it was a constitutional amendment that had as its really moving force reform of the judiciary. So it must have impressed governors and legislators that this is something the people of the state cared about. The result was, I don't know if this was, what happened was they put together an absolutely superb group of people to be on the first Supreme Court. And ever since then, I think that tradition has carried forward. I don't want to put myself as one of the group of superb people, but generally speaking, the appointments to the court have been very, very good appointments. The tradition of the court in scholastic endeavor started with Chief Justice Vanderbilt, Justice Jacobs, and all kinds of great Justice Brennan came from the New Jersey Supreme Court. I mean, these are men of just incredible talent, and they poured their hearts and their minds into the work of the court to make its decisions really scholarly, well thought out, and important, and do the right thing, not afraid of precedent if it was wrong. It's something that they started that we've tried to continue. And I think that's where, to the extent that we've been able to continue it, that's where it comes from.
Well, you certainly continued the breaking of precedent and the setting of new precedent in the first half of the Wilentz years, the 14 years that you've led the court. You did the Mount Laurel affordable housing decision, the social host is liable for a drunken guest decision, the right to die decision, Baby M, outlawing surrogate motherhood. There's a sense, some have, that this court has backed off in recent years from the so-called activism of its earlier years, and that maybe even your experience before the legislature in 1986, your reappointment fight in which the legislature said you were not always deferring to the intent of the legislature, that may have had some chastening experience, been some kind of chastening experience for you. What do you say to that notion?
I don't feel chastened. The social host decision did break precedent, and we do break precedent once in a while. The surrogacy decision, Baby M, didn't break precedent, it made precedent. No court had ever quite passed on the issue before. Mount Laurel, we didn't break precedent. I mean, the precedent of Mount Laurel started with a court that I don't know what the legislature would have said about a most distinguished court, an opinion written by a most distinguished conservative, one might think, Justice Fred Hall. He wrote the original Mount Laurel decision. We're not the court, the activist court that fashioned Mount Laurel. So the idea that we're an activist court and we defer enormously to the legislative will, always have. We should. They make the law. When they make the law, if we don't follow it, we're lousy judges. We follow it. When we get a case that is not governed by legislation, if there is a precedent that governs that case, we'll look at it very, very carefully. We don't want to upset a precedent, but if it doesn't seem to make sense, that's what we think is the tradition of the New Jersey common law. Our predecessors, before I was Chief Justice, established law that was followed throughout the country that had never been law before. The whole products liability law probably started with New Jersey courts, and a whole batch of other things. Right to die cases didn't really break precedent, they established precedent.
Well, some of your critics, particularly from the conservative side of the political spectrum, say that they think judges like you can make the law work whatever way it wants to work. And take a case like Abbott versus Burke, school funding, where maybe you weren't just applying the law, you were looking at the shocking inequality between urban schools and suburban schools and making social policy. Is that what you were doing?
Yes and no. Yes, in the sense that the outcome obviously affects social policy. No, in the sense that what we tried to do was to apply the law as we found it, the Constitution as we found it. And again, the idea that Abbott versus Burke was this court's revolutionary determination about school funding, our predecessors in Robinson v. Cahill were the court that decided that the thorough and efficient clause was enforceable, that the state of New Jersey had to give every kid a thorough and efficient education. And one of my predecessors said that where there is an inequality of funding, absent some kind of showing on the record, we will assume that the mere inequality of funding means that the kids who get less aren't getting a thorough and efficient education. We didn't make that up. That started somewhere else. So the notion that we're somehow activist and me, I don't do it. There are 7 of us of all different kinds of points of view. So what we found before us was a record where the inequality of funding was not only part of the record, it not only had continued, but the consequences of the inequality were demonstrated on that record. And we concluded that as to those districts, the showing was compelling, and that the only way to achieve the constitutional requirement, as we understood it from our predecessors, was to do what we did.
The other criticism of the Abbott versus Burke decision is that you're throwing money at city schools, and money's not the answer.
Well, certainly, as each decision of the court indicated, those of the courts before our court, in other words, New Jersey Supreme Court in the past, and our own decision, we know that money isn't the answer. One can waste money for school, for educational purposes. The court's ultimate view was that these children in the poorer districts who have been gotten really very, very bad education, that they should have a chance to get as good an education as kids in the richer districts. And that money, if properly used, can make a difference. There are some people that say even if properly used, it can't make a difference. The court did not feel able to reach that kind of conclusion. So that the question that's usually asked, if money's so unimportant, why do the richer suburbs spend so much of it on the education? And I think there's not an urban educator around who would take the position that money is not important and not needed. But clearly, the court is not the institution that's going to make sure it's spent right, spent the best way, spent the most effective way. Very difficult problems of education with kids who don't have families, kids who don't have a place where they go where education has been a part of their tradition, kids who go to households that have no father, and kids who go out in the streets. It's a terrible problem that goes way, way beyond education. But public education is something that the Constitution says, and the court obviously tried to follow that. It shouldn't depend on where you live. It shouldn't depend on whether you're rich or poor. Public education.
Chief Justice, you have 4 more years on the bench before the mandatory retirement age of 70 causes you to step aside. What do you want to accomplish in your last 4 years?
Well, I would love to implement a lot of the things that we've started. We have finally reached decisions about the best way to organize and operate the court system. In the criminal division, we're really beginning to move. I would love to see that fully implemented so that the systems that we now are starting to put in place prove, or don't, but I think they will prove, to be enormously effective. And we have a lot of good things in civil. So I would hope that by the time I leave, our caseloads will be being managed in a way so that people don't have to wait 3 years for a jury trial if they want to go to jury trial, so that the complementary dispute resolution program that we've had in place for so long begins to function. In other words, we have it in every vicinage. There's a whole system of advising people of ways to resolve their dispute without continuing their case in court. I would hope that we would be able to implement the kinds of recommendations that would eliminate any vestige of discrimination against minorities and women, that we would be able to accomplish that. And I would hope we could treat the poor in general better than we have. The system has accepted the idea that because a person's claim is so small, and because there are hundreds of people in the courtroom, small claims, landlord-tenant, that you just have to dispose of cases quickly. This has been traditional. What is becoming more and more apparent is that people whose claims are disposed of don't feel they're being given proper attention, and so our very difficult problem, but our dealing with the poor, I think, clearly has to be improved. The family division itself is something that I would hope by the time I get out really has a chance, the judges have a chance to spend more time on their cases. They affect kids' lives, they affect parents' lives, they affect the family's life, and we have tried to take those cases which used to be treated like the bottom of the barrel of the judiciary and give them the importance that they're entitled to. Family division judges have much, much more pressure on them than any judges. We need more family division judges, and we need to be able to have the system work in a way so that people who want to get a divorce don't have to wait months and years and have different days and weeks of trial. So I would hope generally to get the court system in better shape than it's in right now.
And how will you want the Wilentz years remembered? They'll probably be remembered as a liberal activist court. How do you want them remembered?
I would hope only that they be remembered if people don't have anything better to do and they want to remember them as years when a great court system was kept great, and when a great Supreme Court was kept great.
Well, thank you for inviting us into your home and speaking to us. I enjoyed talking to you.
Thank you, Mike, for asking me, and I've enjoyed it too.
When the Constitutional Convention of 1947 redesigned the court system, it created one of the most powerful Chief Justices in the nation. One observer said recently, "We've had strong Chief Justices by virtue of the Constitution, and we've had strong men sitting in the chair." For NJN, I'm Michael Aaron.
This program was made possible in part by a grant from Smith, Stratton, Wise, Hare, and Brennan, a Princeton law firm offering a full range of legal services to the people and businesses of New Jersey.